You missed a toll. Maybe you did not have cash. Maybe your transponder did not register. Maybe you drove through an electronic lane that did not capture your plate correctly. And now there is a law enforcement officer at your window. Not about the toll. Not about the missed payment. About the car. About where you are going. About what is in the vehicle. About whether you have been drinking. About whether he can take a quick look inside. The toll stop is one of the most underestimated entry points into a full traffic enforcement sequence in this country. And it is effective precisely because the stated reason for the stop is so small that drivers dismiss it as administrative and drop every guard they had before the conversation started. A missed toll is not a crime. It is a civil infraction in most jurisdictions. It does not justify a DUI investigation. It does not justify a vehicle search. It does not justify a field sobriety battery. But it happens anyway, because the toll stop creates an encounter, and the encounter creates an opportunity, and the opportunity is used in ways the driver never anticipated when they saw those lights for something that should have ended in 30 seconds. Subscribe to this channel right now, because the video after this one covers the specific escalation that most commonly follows a toll enforcement stop, and knowing what is coming before it arrives is the only preparation that actually works. Before the words, you need to understand what a toll stop actually is, because there are two versions of it operating simultaneously, and most drivers only know about one of them. The first version is the administrative enforcement stop. A toll authority officer, a state trooper, or local law enforcement has been assigned to toll enforcement on a specific roadway. They have been notified of vehicles that pass through a toll lane without payment, typically through a license plate capture system or a transponder non-read, and they are initiating a stop to address the toll violation directly. This is the stop as most drivers understand it. Missed payment. Civil infraction. Pay the toll, possibly pay a fine, drive away. The second version is what the toll stop becomes the moment the officer decides that the toll violation is the stated reason for the stop rather than the actual reason. A toll violation, like any observable traffic infraction, provides the officer with the constitutional predicate for a stop under Wren versus United States. Wren established that as long as a traffic violation provides objective probable cause or reasonable suspicion for a stop, the officer's subjective motivation for initiating the stop is irrelevant to its constitutionality. A vehicle that interests an officer for any reason, its make, its occupants, its prior contact history, its plate return, anything, can be stopped if a toll violation can be observed or documented. The missed toll is the key that unlocks the encounter. What the officer does inside the encounter may have nothing to do with the toll at all. Here is the legal mechanism that makes the toll stop one of the most widely used pretextual stop tools available to law enforcement. And understanding it is what makes asking for the basis of the stop so critical before anything else in the encounter begins. Wren versus United States, decided by the Supreme Court in 1996, addressed a situation in which narcotics officers stopped a vehicle for a traffic violation as a pretext for investigating suspected drug activity. The defendants argued that the stop was unconstitutional because the officer's real motivation was the drug investigation, not the traffic violation. The court held unanimously that as long as a reasonable officer could have stopped the vehicle for the stated violation, meaning the violation objectively existed, the officer's subjective motivation was constitutionally irrelevant. The decision effectively authorized pretextual stops across every category of traffic violation. A broken taillight, a failure to signal, a temporary tag that is slightly crooked, a toll lane transgression. Any observable violation provides the constitutional predicate. The toll stop is particularly useful as a pretextual basis because toll violations are documented by automated systems, plate capture cameras, and transponder readers that produce a paper trail independent of the officer's subjective observation. The officer is not claiming to have personally seen you do something. The system recorded it. The stop is facially airtight. What happens inside the stop is where the pretext reveals itself, and where the driver who knows the difference between the stated reason for the stop and the stop's actual investigative purpose has the ability to create a record that distinguishes between them. Here is what a toll stop looks like when it runs to its investigative purpose rather than ending at the civil infraction. And tracing the sequence is what makes each individual step feel urgent rather than isolated. The officer approaches. He states the toll violation. He asks for your license and registration. This feels administrative. You comply because it seems like the routine beginning of a routine stop. While you are providing your documents, he is conducting the personal contact observations, watching your eyes, listening to your speech, looking for the indicators that justify transitioning from toll enforcement to impairment investigation. He takes your documents back to the patrol vehicle. He runs the license. He runs the warrant check. He runs the vehicle history. He returns to the window. If the administrative stop is all this is, he writes a citation for the toll violation and releases you. But if the personal contact observations produced anything, a perceived smell, a slight hesitation, eyes that seemed glassy in the dark, a nervousness he decided to interpret as something other than the completely normal response of any person who just got pulled over, the stop transitions. He now asks about where you have been. He asks if you have had anything to drink. He asks if you mind stepping out of the vehicle. He asks if there is anything in the car he should know about. The toll violation has been processed. The DUI investigation has begun. And the driver, who believed this was about a missed E-ZPass transaction, is now standing on the shoulder being asked to walk a line. The toll was the entry. Everything after it was the investigation. Here is the piece of legal geography that most drivers never know, and it is the one that determines what the officer actually has the authority to do once the toll stop is initiated. A toll violation in most jurisdictions is a civil infraction, not a criminal offense. It is enforceable through administrative processes, notices mailed to the registered owner, fines, and in some jurisdictions license suspension for accumulation of unpaid tolls. The civil nature of the underlying violation matters because it defines the scope of the enforcement authority. A law enforcement officer who stops a vehicle for a civil infraction has the authority to address that civil infraction, to verify the registered owner, to document the violation, to issue a citation. What the officer does not automatically acquire from a civil infraction stop is the authority to conduct a full criminal investigation. The transition from civil toll enforcement to criminal DUI investigation requires an independent basis. The officer cannot transition to a DUI investigation simply because a stop occurred. He needs independent, articulable observations, things he personally observed at the window or during the stop, that provide the reasonable suspicion required to shift the investigation's focus from the civil toll violation to a potential criminal offense. Understanding this distinction is what makes your response to the escalation so legally significant. The officer who transitions from toll enforcement to DUI investigation based on nothing more than a perceived smell or a subjective nervousness observation is making a legal judgment call that is contestable. The driver who says nothing, who answers every question, who steps out and performs the tests, that driver has helped the officer build the independent basis that justifies the transition. The driver who knows what to say has the ability to put the transition itself on the record and require the officer to articulate what specifically changed between the toll enforcement window and the DUI investigation request. Here is what most drivers do at a toll stop, and both responses accelerate the transition from administrative to investigative without the driver ever realizing the shift has occurred. The first driver engages fully and openly. They explain the toll. The transponder glitched. They were in the wrong lane. They were going to pay it online. They are friendly and cooperative because the stated reason for the stop is minor, and they want to demonstrate that they are reasonable people dealing with a minor administrative matter. Their friendliness, their eye contact, their natural conversational warmth, all of it is being observed and interpreted in a context the driver does not know is active. Every natural behavior of a cooperative person in a low-stakes interaction can be recharacterized through the lens of a DUI investigation if the officer decides to transition. The second driver becomes visibly frustrated. They know the toll stop is administrative, and they resent the implication that it could be anything more. They show impatience, brief annoyance, short answers. The body cam documents the attitude. The report notes behavior inconsistent with someone who has nothing to worry about. The frustration that was completely justified given the administrative nature of the stop becomes behavioral evidence. In an investigation, the driver did not know was happening. There is a third response, the one that addresses the administrative toll matter, provides the required documents, and simultaneously closes the investigative window before the personal contact observations become the transition mechanism. It begins with understanding that the toll stop, however small it seems, is a traffic stop with every constitutional dimension of any other traffic stop. Here is the constitutional architecture that governs every moment of a toll stop beyond the citation itself, and it contains the same protections that apply at every other stop this channel has covered, applied here with specific attention to the administrative to criminal transition that makes the toll stop unique. The Fourth Amendment prohibits unreasonable searches and seizures. A toll stop is a seizure. The seizure's scope is limited to the purposes that justified it. Rodriguez versus United States, decided in 2015, held that a traffic stop cannot be extended beyond the time reasonably necessary to complete the stop's mission without independent reasonable suspicion of criminal activity. The mission of a toll enforcement stop is the toll enforcement, verifying the violation, documenting it, issuing a citation, releasing the driver. Any extension beyond that mission requires the independent reasonable suspicion that Rodriguez demands. The Fifth Amendment protects you from providing incriminating statements at any stage of the stop. The toll stop does not waive the Fifth Amendment. The civil nature of the underlying violation does not suspend your right to remain silent on questions about your activities, your consumption, or your destinations. Illinois versus Cabal addressed the permissible scope of activity during a traffic stop, with implications for what additional investigation is permissible during the stop's duration. The combination of Rodriguez and Cabal creates a framework in which a toll stop can lawfully address the toll violation and nothing more, unless the officer develops independent articulable suspicion during the stop's lawful duration that justifies a transition to criminal investigation. Your responses during the stop are what either provides or denies that independent articulable suspicion. So here are the exact words, structured for the toll stop specific progression because the toll stop moves through two distinct phases and each phase has its own response. Phase 1 is the initial approach, before documents are handed over. The moment the officer states the toll is the reason for the stop. Officer, before I provide my documents, I understand there may be a toll matter to address. Can you confirm this stop is limited to the toll violation? Say it calmly. Say it before the license leaves your hand. Every word is doing specific work. I understand there may be a toll matter to address. You are acknowledging the stated basis for the stop without contesting it, which establishes a cooperative register without producing any admission or information. Can you confirm this stop is limited to the toll violation? This question does two things simultaneously. It puts the scope of the stop on the record. If the officer confirms that the stop is limited to the toll matter, that confirmation is on camera, and any subsequent transition to a DUI investigation is a departure from the stated scope that Rodriguez requires independent justification for. If the officer does not confirm and instead begins asking about your evening, your destinations, or your activities, you know immediately that the toll was the pretext and the investigation has already started. Then hand over your documents and proceed immediately to Phase 2. Phase 2 is any question that goes beyond the toll violation itself. The moment the officer asks anything that is not directly related to the toll, where are you coming from? Have you had anything to drink? Do you mind if I ask you a few questions? You respond. Officer, I am invoking my Fifth Amendment right to remain silent on anything beyond the toll matter. I do not consent to any searches. Am I free to go once the toll citation is issued? Or am I being detained for another reason? Say it once. Keep your voice level. Every word is on the record. The officer will push back, and at a toll stop the pushback often sounds reasonable. It is phrased as natural follow-up to an administrative encounter rather than as investigative pressure. Know every line before it arrives. If the officer says, I just need to ask you a couple of questions while I process the citation. Processing a citation does not create an obligation to answer investigative questions. Officer, I am invoking my Fifth Amendment right to remain silent on questions beyond the toll matter. Am I free to go once the citation is issued? If the officer says, you seem nervous, is everything okay? Nervousness at a traffic stop is a universal human response that courts have repeatedly noted does not constitute reasonable suspicion of criminal activity. Your response does not change. If the officer asks, have you had anything to drink tonight? This is the transition from toll enforcement to DUI investigation without an independent stated basis. Officer, I am invoking my Fifth Amendment right to remain silent. I do not consent to any searches. Am I free to go or Am I being detained beyond the toll matter? If the officer says, step out of the vehicle, comply with the exit. Pennsylvania versus MIMS applies. As you exit, officer, I am complying. I do not consent to any searches, and I am invoking my right to remain silent. On what independent basis are you continuing this stop beyond the toll violation? If field sobriety tests are requested, officer, I respectfully decline to perform any field sobriety tests or roadside evaluations. I am exercising my constitutional right to refuse. If a breathalyzer is produced, officer, I respectfully decline to perform any preliminary roadside breath test. If the stop is extended without the officer articulating an independent basis, officer, I am asserting my right under Rodriguez versus United States to be free from detention beyond the purpose of the toll enforcement stop. On what independent basis are you extending this stop? If handcuffs come out, I want an attorney. For words, everything stops. Here is a dimension of the toll stop that no other legal content addresses, and it is the one that most affects drivers who are stopped for toll violations they genuinely did not commit. Automated toll collection systems that use license plate capture technology have documented error rates. The image capture systems used to record plates at toll locations operate in variable conditions: poor lighting, adverse weather, vehicles in adjacent lanes, partial obstructions of the plate by trailers, bike racks, or debris. The optical character recognition software that reads captured plate images from the camera data misreads plates at a documented error rate that varies by system and condition. A plate that reads as GXR 4421 may belong to a vehicle that legally paid the toll, while a misread plate belonging to a vehicle that looks similar, GKR 4421, is reported as non-paying. The driver of the correctly tolled vehicle is stopped for a violation that never occurred and that the automated system will never self-correct because the error happened at the point of capture. The officer presenting the stop as a toll enforcement action is presenting a system output that may be inaccurate. You have no way to verify it at the window. You have no access to the image that generated the report. You have no mechanism to challenge the system's accuracy in real time. What you do have is the ability to state, on camera, before you respond to anything about the stop's basis, officer, before I provide my documents, can you tell me the specific toll location and transaction that generated this stop? I want to note that I may have paid this toll and the system may have an error. That statement on camera is the first step in a subsequent administrative challenge to the toll authority's records, a challenge that in many jurisdictions results in the citation being voided when the payment record is produced. Here is the jurisdictional complexity that makes toll stop rights particularly important in regions with multi-state or multi-agency toll systems, and it is the one that creates the most confusion about which law applies and what the officer's authority actually is. Toll enforcement in many regions involves multiple agencies: the toll authority's own enforcement officers, state police who patrol the toll roads, and in some cases local law enforcement with concurrent jurisdiction on toll road exits. These agencies have different enforcement authorities, different training, and different legal frameworks for what they can do during a toll enforcement stop. A toll authority officer may have limited law enforcement authority to address toll violations and civil infraction enforcement, but not the full criminal investigative authority of a sworn law enforcement officer. A state police officer conducting toll enforcement has full law enforcement authority, but is still constrained by the same constitutional framework that applies to every other stop. The distinction matters because the scope of what each type of officer can do during a toll stop varies, and a driver who knows what the officer's authority is has a clearer picture of what the officer can and cannot do during the encounter. Asking the officer to identify themselves and their agency before any encounter proceeds is not confrontational. It is the information you need to understand what legal framework governs the next several minutes. Officer, can you identify yourself and your agency for the record? Said calmly, before documents are produced, is the first question that sets up everything else. The body cam is running from the moment the officer exits the patrol vehicle, and the toll stop body cam footage is particularly significant in any case where the stop transitions from civil toll enforcement to criminal investigation, because the transition is what judges review most carefully in suppression hearings involving toll-initiated stops. The critical question in those hearings is always the same: what independent, articulable, specific observations did the officer make during the lawful duration of the toll enforcement stop that justified the transition to a criminal investigation? A driver who asked the scope question before handing over documents, who invoked silence on anything beyond the toll matter, who asked for the independent basis of any extension. That driver has given the judge a body cam recording that documents every step of the transition sequence and every moment where the officer either articulated an independent basis or failed to. That recording is the suppression motion's primary exhibit. A driver who engaged naturally, answered every question, and stepped out when asked. That driver's body cam shows a cooperative encounter that produced the officer's independent basis through the driver's own responses. The transition was documented but not challenged. The independent basis was built by the driver's own words. The suppression record is thin. The body cam is the difference between those two outcomes. Make sure what it shows is a driver who knew the toll stop was a traffic stop, with every constitutional protection a traffic stop carries, from the first word to the last. Memorize these before you close this video. When the officer states the toll as the reason for the stop, before producing any document. Officer, before I provide my documents, I understand there may be a toll matter to address. Can you confirm this stop is limited to the toll violation? If the officer confirms, hand over documents, let the citation process complete, then, am I free to go? If the officer transitions to any question beyond the toll, officer, I am invoking my Fifth Amendment right to remain silent on anything beyond the toll matter. I do not consent to any searches. Am I free to go once the toll citation is issued? Or am I being detained for another reason? If the system may have an error, I want to note for the record that I may have paid this toll and I intend to challenge the system's accuracy through the toll authority's administrative process. If the stop is extended beyond the toll matter without independent justification. Officer, on what independent basis are you extending this stop beyond the toll enforcement purpose? I am asserting my right under Rodriguez versus United States. If field sobriety tests are requested, decline. If a breathalyzer is produced, decline. If an exit is ordered, comply. Continue invoking silence and non-consent. If handcuffs come out, I want an attorney. 5 positions, all grounded in Rodriguez, Wren, the Fourth Amendment, the Fifth Amendment, and the specific legal distinction between a civil toll infraction and the criminal investigation that the toll stop is sometimes used to initiate. This is educational content only and does not constitute legal advice. Always consult a licensed attorney in your jurisdiction for guidance specific to your circumstances. If this video reached you before an officer ever used a missed toll to open an encounter that was never actually about the toll, it did exactly what it was built to do. Subscribe to this channel right now, because the toll trap is one of the smallest stated reasons and one of the most consequential actual entry points into a full traffic enforcement sequence, and it sits inside a system of stops and escalations that this channel covers one by one, each with its own legal framework, each with its own exact words, each built so that when the moment arrives you are not caught off guard by the size of what a small violation can start. One scenario, one constitutional foundation, one set of words, so that when those lights appear for the smallest reason, you know that small reasons are used for large investigations, and you know exactly what to say before the investigation starts. Subscribe. Share this with every driver you know. Someone watching tonight is going to be stopped for a $1.50 toll next week and spend the next 6 months fighting a DUI charge that started at a toll plaza at 11 o'clock on a Wednesday night. Make sure they know the toll was the trap. Make sure they know what to say the moment the officer confirms it. Make sure they go home protected. Stay calm. Stay protected. Stay free.